Hello, welcome to our latest in our series of GDPR compliance and beyond. What's next? We've done a series of these webinars for those of you who haven't joined us before, and this is the fourth in the series. I'm Laura Gell. I'm a partner in Baker Hostetler's Washington, D.C. office. With us today are my colleague Stephanie Malaska, who's an associate in the D.C. office with me, and Betsy Dellinger, backed by popular demand, General Counsel of Park Place Technologies, an international technology company, who has been working diligently on international data privacy compliance. Our program today will last an hour and is pending 1 hour of CLE credit in New York and California. For all other states, attorneys can receive a certificate of attendance and electronic materials if they can file directly with CLE credentialing entities. During the course of the webinar, we'll share 2 codes that you'll need to enter into a brief CLE questionnaire immediately following the program's conclusion. Please stay logged into the presentation system for this questionnaire to appear. Please make sure to answer all the questions if you'd like us to submit for CLE on your behalf. If you have any questions during the presentation, you can type them into the bar at the right side of your screen in the questions area. We'll try our best to answer them at the end of the program. Usually, to be honest, we don't manage to answer them during the program, but we do answer them after and follow up with you in writing if you submit questions to us. For those of you who haven't joined us before, this is the fourth in our series. If you'd like to listen to past presentations, please go to www.bakerlaw.com/events. You can also find the recordings in the events section of the Privacy and Data Protection Practice Area page. With that, so today's topic, GDPR versus the new California Consumer Privacy Act. How do they, are you done yet, having worked on GDPR compliance? Or if you haven't started on GDPR compliance, should you wait and try to do it all at once? So we'll tackle some of the similarities and differences of the 2 laws. We'll also take a little bit of a deeper dive into the complications around handling GDPR personal data breaches. There's been a lot of discussion about the 72-hour data breach notification obligation. Turns out that isn't really the only complicating factor as we start to work through these. So we'll walk through some of the challenges that you may face if you have a GDPR implicated breach. We'll turn to just quickly updating the most recent guidance and enforcement actions out of the EU data protection authorities. Today's quote, in comparing various authors with one another, I've discovered that some of the gravest and latest writers have transcribed word for word from former works without making acknowledgement. That's from Pliny the Elder. We're getting fairly serious today. I think that's a reference, I'm pretty sure it's a reference to the many similarities between the California Consumer Privacy Act and GDPR. I think, I just covered where we're going in the presentation today. So jumping in, to remind everybody, we always start with just a snapshot of the GDPR. It became effective on May 25th, so not quite 6 months ago, I guess 5 months ago now. It applies to organizations that are either established in the EU and that means have even one employee or physical establishments, physical locations in the EU, process personal data of EU data subjects when offering them goods or services, whether or not you get paid for those services, or monitor behavior occurring in the EU, behavior of individuals. The key terms under GDPR is personal data, which I think we've mentioned a number of times, really includes anything that can be used to identify an individual, even just your name or your email address or your IP address. Processing, which is really anything you're doing with data, whether it's collecting it or storing it or running some kinds of data analytics or other use of that data. And then the 2 key distinctions, 2 key roles under GDPR are data controllers, who are the entities that direct the processing. They essentially are, if you think of them, are the folks who generally collected the data and telling other people what to do with it. And processors, who are like data processors here, somebody that's being told what to do with the data but is not doing that action at their own direction. And as always, we remind you of the fines under GDPR, the greater of either 20 million euros or 4% of worldwide annual turnover, which in the US we refer to as annual revenue. So now turning to a quick snapshot of the California Consumer Privacy Act, this law came into effect unexpectedly for many people. There was a ballot proposition out there, which is, the way California allows folks to write their own ballot propositions, and if they get enough signatures, they can get it onto the ballot in California. There was a data privacy law that had gotten enough signatures to go on the ballot. It was even more restrictive than what has now been enacted, and there was a deal cut essentially between the tech companies who were concerned about the restrictive new law that could take effect if enough votes. If it got enough votes in next week, in November, when the election would be held, and the tech companies didn't really want it. The promoters thought they had enough votes, and so a deal was brokered to pass a somewhat watered down law over 2 days, because the time was running out before it was actually going to go on the ballot. So it was passed sort of unexpectedly June 28th. Of this year, so just a month after GDPR took effect, and it really sort of blindsided many of companies and data privacy lawyers who thought they had just gotten through dealing with the big hump, and now they have a brand new law to deal with. So the CCPA, which there seems to be a battle brewing, or whether it's called CCPA, C-A with lowercase a, CPA, which is one preferred abbreviation that so people would understand it's California, but right now we're going with CCPA. It will take effect July 1st, 2020. Compliance obligations kick in January 1st, 2020, because there are look-back provisions. We'll talk back. Is broad scope and application of the law. It protects what they call the personal information of what they call consumers. Those definitions end up being quite similar, although of course not identical, to personal data of data subjects under GDPR. CCPA gives consumers greatly enhanced rights over control of their personal information. The fines are not quite as onerous, maybe, as the GDPR fines, although there's enough ambiguity in the law that it's not really clear what the limits are in terms of some of these are per violation, and it's not clear necessarily what constitutes an individual violation. But the Attorney General of California can impose up to $2,500 for each violation, or $7,500 for each intentional violation. And the violating entity can be subject to injunction. There's a private right of action, which is available to consumers as essentially as a class action right, only if the Attorney General declines to take action. So the consumers have the right to bring a complaint to the Attorney General. If the Attorney General says, I'm not going to do anything about that, consumers then have a private right of action on their own. And they can bring these actions only, not for the privacy aspects of the law, but only for the data security aspects of the law. So they can bring an action for a business's alleged failure to implement and maintain reasonable security procedures and practices that result, and if that failure results in a data breach. So I'll turn it to Stephanie to talk about the applicability of the law and some of the details.
Sure. So the applicability of the CCPA is a little bit more complicated than that for GDPR. I'll sort of run through the provisions here and then talk a little bit more about them. So effectively, the law covers any for-profit business that is doing business in California, so not just physically located there, but engaged in any sort of for-profit business, and then meets one of the following three criteria. So it either has over $25 million in revenue, or it annually buys, receives for commercial purposes, sells, or shares for commercial purposes the personal information of 50,000 or more consumers, households, or devices. So as Laura mentioned earlier, consumer is construed fairly broadly as well, just to California residents. One of the ambiguities we run into there as well is that California resident is defined in a way that references another part of the law, which encompasses people who may spend part of their time in California. It's sort of a difficult delineation to determine who actually falls within the umbrella of a consumer. And then again, third criterion, or if the company derives 50% or more of its annual revenues from selling consumers' personal information. And one of the interesting parts about the applicability here is the way the law defines selling. So it's not just in the traditional sense of, handing over data for some value, but it's really selling, renting, releasing, disclosing, disseminating, transferring, or otherwise even communicating orally by writing or electronic means a consumer's personal information for monetary or other valuable consideration. So effectively, if you're receiving some sort of return on the communication in any way of personal information, you can fall within this as well. So just from that provision alone, it encompasses a lot of businesses that are involved in California. You can also come under the umbrella of the CCPA by being controlled by a business that is covered, so something that shares common branding or is within sort of the same company structure. And the CCPA has applicability to service providers as well, so what we think of as vendors or sort of similar to GDPR's processors, entities that are doing business on behalf of a CCPA covered entity. And I'll go through here. It's important as well to understand what the CCPA does not apply to. So by its name, it does not apply to commercial conduct taking place wholly outside of California. So in particular, that means it's very specifically drawn. What the CCPA does not touch is activity where a business collects personal information while the consumer is outside of California, while no part of the sale of the consumer's personal information occurred in California, and no personal information was collected while the consumer was in California, and that information is not sold. So effectively, it's something where I think it's safe to say that California is not involved at all from the company side or the consumer side. Additionally, like GDPR, it does not apply to any processing of non-personally identifiable or aggregated information where it's not possible to identify an individual. And as well, there are some exemptions toward the end of the law where a company is retaining or otherwise processing data for compliance with legal obligations, including legal holds, any compliance with law enforcement direction, and then certain other categories of data such as health data, GLBA information, clinical trials, data collected there is not covered by CCPA.
I'll just add on that California conduct, the question of whether the conduct is taking place wholly outside of California or while the consumer is outside of California, while it's, clearly has to be in the law because California doesn't have jurisdiction over conduct that takes place outside. As a practical matter, trying to comply with this, trying to figure out where the person was at the time the data was collected, particularly retrospectively, is probably not an exercise you really want to engage in unless you absolutely have to. I think this, the nature of the California law and the nature of the jurisdictional claims suggest that there's going to have to be overbroad application. You really aren't going to want to be spending your time saying, well, were they in Arizona when I got this, or maybe they just crossed the border? At some point, you're just going to have to treat California, everybody as if they're a California consumer, unless they're very clearly not.
Right, and that's a really good point to bring up as well. So, again, by the title of the law, the California Consumer Protection, or forgetting that acronym. Anyway, so the CCPA grants a number of very distinct rights to consumers, and that's actually the main emphasis and one of the main differences between the CCPA and GDPR. So what it does is it really expands the rights available to California residents over their personal information. I'll run through a number of those rights here. So one of them is sort of similar to the access right under GDPR. It's just the right to know what personal information is being collected about them, including a lot of the details about that collection. So it really places granular specific requirements on companies to know exactly what's happening with that data, where it is, why they're collecting it, because consumers are entitled to know the sources from which it's collected, exactly what types or categories of personal information is being collected about them, the purposes for the collection or sale of the data, and remember that sale is a very broad term, and the categories of third parties with whom it's shared. So again, you can already see that this requires a lot of data mapping to be compliant. As well, consumers are entitled to access and download their personal information in a way that is transferable, and a new sort of provision for the law is a right to refuse to allow companies to sell their personal information. So it's an opt-out provision as opposed to an opt-in, but a consumer can effectively ask a company not to share their information with an outside party whatsoever. I believe there are a couple exceptions to that, but by and large, available. And then as well, a right to deletion, again, with some exemptions, a right to request that the company get rid of the personal information that they're holding. So in addition to providing California consumers with certain rights over their personal information, the CCPA also places affirmative obligations on businesses to not only accommodate those rights, but to sort of create certain processes and realign their operations in a way that complies with the requirements of the Act. So I think one of the things that Laura mentioned in the retroactive or the sort of running ahead part of the law is that record-keeping obligations will kick in slightly in advance of the effective date, because I believe that the term in the law is record-keeping for the last 12 months. So companies should be prepared to figure out what they need to keep track of and begin those record-keeping obligations fairly soon. And as well, privacy provisions must be included in service provider contracts. So a lot of contracts with vendors and other service providers will need to be updated. As well as with any privacy law, change to privacy laws, privacy policies and notices, other sort of notices given to consumers will have to be updated in accordance with the new requirements. And in order to comply, companies will also have to implement new internal processes, just mapping their data flows again to comply with all of the requirements and the rights given to consumers, implementing procedures for taking in, validating, and responding to those consumer requests with regard to personal information, and also implementing programs where they are not discriminating against consumers who exercise these rights. So consumers who may be opting out of the sale of their information or directing companies to delete it, companies will need to make sure that they're not, taking away the services given to those consumers. And the CCPA also offers an opportunity to create kind of incentive programs. It's a little bit of a difficult divide, I think, between these two things. But what companies can do under the CCPA is provide certain incentives with regard to the value of the personal information being provided. So there are ways to sort of implement little carrots to give consumers a reason to turn over some personal information.
So looking back at sort of the big picture, now that Stephanie's done a little bit of a deeper dive into CCPA, how are GDPR, if you're trying to comply with both, how are they similar and how are they different? They both have extraterritorial reach. They both apply not just to conduct taking place, within the EU or within California, but to any conduct that, by and large, that offering goods and services under the GDPR, or conduct where Californians are transacting with others outside the state. They both have a very broad definition of personal information or personal data. Those definitions, I think I said before, are not identical, but they're very similar. You really do get to anything that can identify an individual. Interestingly, under the California definition, it's also anything that can identify a household, which, opens a whole new can of worms. What's a household?
It's not defined in the Act, I'll add that.
Right, is it sort of like, are my adult children, if I have adult children, are they in my household, even if they don't live there, but they're at college? Those get down, you can get down a rabbit hole really quickly with some of these definitions. The data subject access, they both laws have rights of access, deletion, and portability. GDPR has some additional rights, but the right of deletion under CCPA is not terribly different than the right of erasure under GDPR, which is what was originally giving everybody fits, the idea of actually getting rid of data completely. Now, even if you resisted that, and some companies really tried hard because they were concerned about those data subject rights not to have to be subject to GDPR, it's going to be hard to get around it with the California law. So that argues again in favor of very thorough and comprehensive data mapping to make sure when you get rid of it, you can get rid of all of it. There's, under both laws, there's a requirement to notify consumers about your privacy practices, either prior to or at the time of data collection. What you have to tell them is different, but you do have to notify them about your practices. There are some similarities. lots of similarities, actually. You have to notify consumers if you change your privacy practices. There are special rights under both laws for children, and there are time limits for fulfilling the data subject requests. GDPR gives you 30 days. California graciously allows you 45. And both laws have penalties for data breaches. Although, as we discussed before, they're a little bit different in that one is sort of a mandatory or a permissive regulatory fine, and the other is, is a regulatory fine by the AG potentially, or a private right of action. So how are they different? Here are some provisions that are only in the California Consumer Protection Act. The right to opt out only covers the sale of personal information. It's the sale. You can have they want you to have a button on your website that says, "Do not sell my personal information." It doesn't say, "Do not share my personal information," and it doesn't say, "Don't keep any of my personal information," or although there is that right of deletion you can access. The button that they talk about, that's such a huge change in privacy law that people talk about this law being so draconian. It really is in some ways fairly limited to sales of data, and although many companies do sell data, many of them don't. CCPA also establishes specific communication challenges for consumers. You have to have a toll-free number and a conspicuous link on your website. It extends the personal information protections, the definition of personal information, to information about your devices and your household. So the device definition, I think, it's an important one, and it's a realistic one given how much tracking and identification of you as an individual can be done through identifying your device. But that is not a distinction that the Europeans thought was important to include. There is a 12-month basis of record keeping. I think Stephanie mentioned they adjusted after the law passed when the look back is. So the law now, there's a 6-month lead for the first record keeping period. You have to start keeping records in January 2020, and the law kicks in July. But by and large, you have to keep records, on a 12-month basis and provide information once a year if you are requested to do so. And then there is, like I mentioned before, the private right of action connected to data security and data breaches.
So I'll jump in here. Laura mentioned in pointing out some of the differences and similarities. Privacy notices for both GDPR and CCPA are important. However, unfortunately for businesses covered by both, they are not so similar. The requirements are not so similar to be something that can be sort of used doubly or, make anyone's life all that much easier. A lot of the requirements are sort of similar. You need to disclose, the types of data you're collecting and generally the reasons why. However, the differences in format, for instance, GDPR does not need to be online. California does. California requires that the notice be updated every 12 months, and a number of other sort of nitty-gritty things we have listed here. But what's really important to note is that, if you're going to be putting up privacy notices and you're covered by both of these laws, you'll have to make a determination as to whether you want to grant those rights for GDPR and CCPA to all visitors to the website, whether you're going to have separate policies for each, as well as just U.S. visitors or regular U.S. policy, and if you're going to have separate ones, how you're going to delineate and make sure that it's clear which rights are being granted to whom. So again, another instance of these laws being sort of painfully similar, but not quite enough.
So that, that's how the laws are similar and how they're different. Betsy, from your standpoint, you have to actually put into place compliance programs to comply with both these laws, as well as some others we haven't talked about, including some new laws coming internationally in Brazil and other places. What challenges do you see, and how do you approach having a whole new privacy law to comply with after just going through your GDPR process?
Yeah, you know what, I would say, well, first of all, on your website, we might now need to have a whole website of radial buttons once you finally get through the cookies banner. The way it starts to look with all of this. So you have to figure out how to consolidate it and present it in for our purposes, a customer-friendly platform. I will say that GDPR was not my favorite part of the fall of 2017 and the first part of 2018. But now it's really a question of the devil I know, which is GDPR, versus the devil I don't know or am learning, which is the CCPA. And we are international, so we're also keeping our eye on the Brazil privacy law, and there's some privacy laws out in Singapore also, and other jurisdictions that we're mindful about. So we're sort of torn because we have this concept of you want to manage multiple jurisdictions to the extent and the scope that those jurisdictions have laws that apply to us. But now that we have at a minimum 2 significant regimes to comply with more coming down the pike, or do you alternatively flip it around and manage to the most restrictive provisions of each law, so that even for either a national or an international focus, that you are protected, which would be a fairly risk-adverse way of doing it, so that you're taking the most conservative approach possible. So which way do you pursue that, or do you decide you sort of take the key features of both and sort of meld them and take on some planful, modest risk? So we explore that, and sitting in the seat of the general counsel of the company, I sort of have to map that out and make the recommendations on that. What I also don't want to do is to basically take that conservative approach and inadvertently grant rights by commitment or contract to persons who otherwise are not protected by a legal regime. So if we make certain commitments in our privacy notices, for example, or our terms of use, because we decided to go with the most restrictive law, we've now granted those rights to people across the globe who otherwise aren't entitled to those rights by the laws of their jurisdiction. And there's ways of sort of sorting through that, but those are all the things that we need to start to think about in terms of these multiple regimes of law. I would also say that every time a new law comes into place, and we're again looking at now multiple jurisdictions, it hits obviously basic compliance processes in the organization and our data mapping, but then it also hits our website privacy policy in terms of use. We have provisions for data privacy in our customer contracts. We have training programs for our salespeople. We have our employment agreements, employment letters, and HR practices and policy manuals, as well as our HR personnel who need to be trained. And then we also have, our whole IT team that needs to understand what's a breach, when to alert, when to log, and et cetera. So every time there's one of these new logs, you have all these different touch points. So it's not that I can take a look at these, do my personal learning, heads down and put out a plan. It really is very collaborative. But in a company like ours, we tend to collaborate on things that contribute to the growth and success of our organization in a very affirmative way. And so collaboration on sort of legal compliance across the globe on privacy policy starts to feel a little more like chaos. So that's how we're forced to manage through this and some of the challenges. It's a little bit like herding cats, through a maze of new regulations.
Well, it sounds like it turns almost everybody in your organization, or at least anybody that touches any of these functions, whether it's IT, whether it's HR, or touching any kind of customer data, everybody suddenly becomes like a little bit of a little mini data protection officer. They all have to know all of these laws and be able to issue spot and say, oh, wait, this person's in California, they can't have their data sold, but this person's in Europe and they have a right of erasure. It gets to be pretty complicated pretty quickly for lots of people who wouldn't normally have had that in their job description, it sounds like.
Right, exactly. So we try to coach on issue spotting, and I know there's a lot of anxiety about GDPR, but we had done enough work in the background that our communication to sales on May 25th was for the most part, do everything the way you are currently doing it, because we created the protections in the background. With the one exception being if a customer says something about delete me or erase me, contact legal immediately, right? So don't just try to say, oh yeah, I deleted you from my contacts list. That is not sufficient. What tends to happen in my company, I suspect it's true in many companies, is that if you say, here's the general rule, but here are all the nuances related to it, none of the nuances get remembered, so only the general rule gets remembered. So, for example, if you say you can't share private information, except for these like 75 exceptions, everyone's going to say, oh my God, how can we do business? We can't share any information. so there's a level of education and process to build into the mix. And it needs to be constantly reinforced, because unless law and privacy is a big part of your day every day, you're not going to remember those subtle distinctions. So I would also like to just add on California, the private right of action, even if it's somewhat limited, takes it to a different place in my mind as an in-house lawyer, because it makes it much easier for there to be assertions that generate claims or potential litigation that even if we have done nothing wrong and are on the right side of the law, now require resources to manage and resolve. So that private right of action is a powerful tool for people. It's a good tool for people who've been wronged. It's a powerful tool for people who are looking to lever that law to some quick payouts from companies who don't want the hassle.
I think that's right, and I think it's also notable that that private right is associated with data security, with data breaches essentially, and it's a little bit of a conflict, because you hear all the time in the data security, cybersecurity conferences, there's sort of this cliche where the only companies that there are people that have been hacked and people that don't know yet that they've been hacked, kinds of cliches about if you haven't been, you will be. So if that really is the reality, handing a private right of action over, to, anybody to try to prove that you were somehow negligent or wrong in not keeping adequate levels of data security does invite at least, expensive discovery and other kinds of burdens that you wouldn't have, or that might not feel totally fair if indeed the environment is such that everybody gets hacked or everybody's employees get phished at some point. Which is a good time to turn to our next topic, which is data breaches under GDPR. Leaving aside California for the moment, because that regime is not yet in place, and we haven't yet had to respond to any sort of particular nuances of that law. GDPR is in effect, and we've now got 5 months or so of experience in responding to personal data breaches that implicate GDPR, and have some lessons learned and some cautions for anybody having to think about how to respond to one.
So we'll start off with the basics. What is a personal data breach under GDPR? So it's defined as a breach of security leading to the accidental or unlawful destruction, loss, alteration, unauthorized disclosure of, or access to personal data transmitted, stored, or otherwise processed. So relatively broad definition, as most of them tend to be under GDPR, but what's important to note is it's not really what we think of as a data breach in the US, at least in sort of our traditional sense. It encompasses a lot more, including just disruption of access to data. So in its guidance, the Working Party for the GDPR defines 3 different types of data breaches. There's a confidentiality breach, where there's unauthorized or accidental disclosure of or access to personal data. There's an integrity breach, where there is unauthorized or accidental alteration of data, and availability breach, where the data is lost or destroyed or just not able to be accessed. So effectively what this means from a definitional point of view is that anything that causes a loss of access to or a sort of undermining of the data in any way will have to be treated as a personal data breach, triggering all of the obligations, including notifications, reporting, record keeping. All of those will have to apply to something even as simple as a minor and short-lived ransomware attack, or even, as Laura has pointed out, a power outage that causes loss of access to certain data.
So, the initial considerations, there's been a lot made of the fact that GDPR has a 72-hour notification obligation to the supervisory authorities in the EU. And that's really short compared to the U.S. The shortest reporting obligation in the U.S. is 30 days in Florida, state law obligation. So how does this play out? if any of you have ever had the misfortune of suffering a data breach, the way they come up is, someone says something weird's going on with my machine, or the systems are down, or the server's really slow and acting funny, or you get a ransomware notification, demanding Bitcoin to unlock your systems. So there's a period where it's like, what just happened? Have we been hacked? What did we, or what's the nature of this incident? And then, what's impacted? Is it one person's laptop? Is it one person's mailbox? And we'll talk about those because those are very, very prevalent right now. Is it a whole server? Is the data that might be affected, do we know that the scope of it? Is it all of our systems? Do we know the scope of the data? And once you start to think about, what's on that server or what's in that mailbox, is there any personal data of anybody in Europe on that? That's got to be among your first questions, given the 72-hour notification obligation. So usually the first thing you do after that, maybe your IT people have done some investigation, but generally you get often a law firm involved who then retains a forensic firm under privilege so that the results of the investigation aren't discoverable. To get that fired up, you suddenly have to think about GDPR obligations. So you have to have your engagement letter with your law firm needs to make clear that who's a controller and who's a processor. It turns out that law firms are considered controllers under GDPR, so the law firm and the client in a data breach situation are likely joint controllers, and they have to allocate in a transparent manner under GDPR the responsibilities of the controller. And really what happens is the law firm takes on the responsibility to direct the processing by the forensic vendor who becomes the processor. And that ends up creating a situation where your structure looks parallel to a structure you'd have in the US to preserve privilege with the forensic vendor, even though the EU law doesn't have the same concept of attorney-client privilege in most member states, I should say. You have to have these data processing agreements among the parties, right? Because anytime you're sharing personal data with another party, you need a DPA. That's your forensic firm. If you and the law firm are joint controllers, you don't have to have a DPA there. But if you're having somebody else do manual review or anybody else, there has to be a DPA. There also has to be a valid data transfer mechanism if any data is being transferred in connection with the investigation. If, say, the firm is pulling data from servers in the UK, but the team in the US is processing it, they either have to be Privacy Shield certified or there have to be model clauses in place. And then while you're figuring all that out in the first 72 hours and still investigating your breach, you have to start thinking about your notification obligations. Who's going to do the reporting? To whom? Where do you report? Do you have a lead supervisory authority or do you not? In which case you might still have to report in multiple EU jurisdictions. And will there be required notification of the data subjects? So you have to start thinking about all that really quickly. The good news is that the initial 72-hour report, the initial report to these authorities is usually, but not always, made via portal, and sometimes, but not always, available in English, and that you can answer pretty vaguely on most of them, essentially saying, we don't yet know, to the answer to most of the questions. Generally speaking, you will have a later obligation to supplement, but at least you get a report in, but it isn't as onerous as describing every detail of an incident that you don't yet know. So, how do we start our investigation analysis? I think Stephanie can walk through sort of the initial questions you need to ask.
Sure. So, as soon as a data breach, pops up on your radar, one of the first questions to ask is, of course, whether the entity is subject to the GDPR. So the best place to start generally is just to do an applicability analysis. I think we're all fairly familiar, but just whether they're offering goods and services, established, monitoring behavior in the EU. And if you determine that they are subject to GDPR, then you need to determine whether the incident constitutes a personal data breach and then triggers all of the obligations with regard to that breach. So that involves figuring out the types of personal data affected or whether any personal data is affected at all, and whether there are any special categories or sensitive information. The more of a handle you can get on the types of personal data that were affected, and the earlier you can do that, definitely the better. And then in the initial stages, you're going to want to determine and manage your reporting obligations across the jurisdictions. So in a traditional sense, that would entail, as Laura mentioned, reporting obligations to any EU supervisory authorities, or whether there is a lead supervisory authority, as well as data subjects affected, and if you can get a handle on where they are, that's important as well. And then any specific obligations with respect to those reports, including languages that those reports need to be made in. And then finally, whether the entity is a controller or a processor or both. If they are a controller, they will be the one to do the reporting themselves, and they may have obligations to joint controllers as well. Or if they're a processor, they'll have obligations to the controllers of the data that was affected. So some differences there as well.
I think I just covered briefly most of the ideas around these third-party data processing agreements. You do have to have them in place with anyone with whom you're sharing EU personal data. And so if if it's a forensic firm accessing your systems, or retrieving forensic data that involves access to someone's email box or something else, they will need to be subject to a DPA. And sometimes there are other entities involved. Sometimes there are outside, like the major corporations often outsource their IT functions to another corporation. And sometimes if you have one of these breaches that involves a mailbox, you're going to have a lot of manual review, and that's a different vendor. Everybody's got to be covered by a DPA, and they've got to make sure that their roles as controllers, processors, and sub-processors are adequately established and papered. And while you're doing that, assuming your breach is also affected, under U.S. law, often you'll have commingled U.S. and EU data, which is another challenge. You need to make sure that you structure your engagements to still protect the privilege and your rights under U.S. law.
So if you have determined that you have or most likely have suffered a personal data breach and you've gotten all your DPAs in place and you're ready to go, another thing obviously that's going to be on your radar within that 72-hour requirement is what your notification obligations are and where those need to be done if necessary. So just to start out, that 72 hours starts the clock when you become aware of the data breach. So in general, the definition of aware is pretty straightforward. I think it's pretty common sense. The guidance lends a little bit more clarification to this, but it's really when you understand that something has happened. So it's whether you log into your system and you're locked out and someone's run a ransomware attack, or whether there's a USB that had personal data on it that's been lost, or there's evidence of unauthorized disclosure, anything like that. And there's a little bit of leniency in the 72-hour requirement, or when that starts ticking, because you're allowed a brief investigative period to determine whether you actually have suffered a personal data breach and whether you've got to then move down that path of meeting all the obligations. So, I think we're frozen here. Keep speaking to the next slide, even though it's not.
Yeah, it looks like our screen is frozen. We'll see whether it moves forward.
Sure. Anyway, speak off the notes here. So with respect to the notification obligations, as we've said, there are obligations to the supervisory authority as well as to the data subjects, and those kick in at different points and under different circumstances. So the notification to the regulator is required unless the data breach is unlikely to result in a risk to the rights and freedoms of natural persons. So that's a relatively low standard. It's sort of a more often than not, unless it is unlikely. And with respect to notifying data subjects, that requires a little bit more of a heightened standard of severity for the breach. So that's required if the breach is likely to result in a high risk to the rights and freedoms of natural persons.
So when we get to the point of notifying regulators, that's when it starts to be a little more complicated than you might have thought. Part of it is, where where are you notifying? If you have a lead supervisory authority, and you're supposed to have identified a lead supervisory authority by now, if you have multiple establishments in the EU, then you notify your lead supervisory authority. If you're really lucky, your lead supervisory authority is in an English-speaking jurisdiction. The UK ICO, and the UK, of course, is still part of the EU for now, has a very handy, easy-to-use web portal. The Irish DPA also has a handy, easy-to-use portal. But if they're not, you may find that you are obligated to report in 72 hours in Hungarian or in Polish or in Dutch. The Dutch website, Dutch regulatory website, has a nice little thing on the front page where you can click on the flag of the language you want it to be in, and that it offers the text in English. That is actually only available on the first page of the Dutch website, and if you click down lower, which is actually where data breach reporting is, it has to be in Dutch. If you find that out the last minute, as I will admit that we did in one incident, it's somewhat disappointing at midnight on a Saturday night when you're trying to report in 72 hours. So it's important to know in advance, by and large, where you would have to report, and think about where you have to report, and take a look at the website reporting obligations or opportunities, whether they have a portal, whether there are language requirements. I'll take a minute to promo. We will have a new feature coming up on our firm website, which is a map of the EU, which will have interactive information, the information that we know so far about reporting in these jurisdictions, and links to the portals. So if it'll have special information about language requirements and things like that. So this calls into pretty clear focus the benefit of having a lead supervisory authority. If you are a US-based company who's not established in Europe, you can't have a lead supervisory authority. So if you have a data breach that affects individuals in multiple jurisdictions, you have to report in multiple jurisdictions. People kind of forget that. They think, okay, I'll just pick one and go there. That's not available if you're not established in multiple jurisdictions. You have to report wherever the data subjects are. And the other thing to remember about reporting, although the authorities have been really, they haven't done a lot with these reported breaches unless they're really big, because they're trying to get it right. They're not trying to come down too hard on people. Sooner or later they're going to, and if you report a breach but you also have done nothing whatsoever for GDPR compliance, remember that you may be inviting further scrutiny of your practices by reporting a breach. So who should do the notification? Not every organization has a DPO. Some may have Article 27 representatives, who are those representatives established in the EU just for purposes of talking to the EU regulators. Many don't. What happens if you don't? You're supposed to have something, right? We have done the reporting for a number of our clients. Outside lawyers have done it, some in-house people, sometimes in-house people in the country. And so far, we haven't seen any pushback. I've yet to see a case where somebody says, where's your DPO and why aren't they reporting to me? But that really depends on the kind of company and the nature of the data processing they do and whether they're supposed to have a DPO. And certainly if you have a DPO, there are all sorts of issues around communicating with that DPO and risking attorney-client privilege in the U.S. because the DPO is not a lawyer generally, or certainly not acting as a lawyer. They're acting as a DPO, and there may be issues. They also are required to be fully informed about privacy matters. And they can't take direction from others. They can't be told what to do on privacy matters. So there's a delicate line to walk there if you're trying to preserve attorney-client privilege. Notifying data subjects. Stephanie, you want to tell us when data subjects need to be notified?
Sure. I think we walked through the standard a little bit ago, but just something where if you've discovered your breach and you've done your notification to the regulator, now you're thinking about whether or not the data subjects themselves need to be notified. So again, this is the heightened standard of whether the breach is likely to result in a high risk to the rights and freedoms of natural persons. Again, kind of a mushy standard. I think there are certain types of data that we would classify as clearly requiring notification, and then some that it's hard to determine whether or not that would really result in a high risk to the rights and freedoms. And again, that's not something that's eminently clear what it means under GDPR. But in the event that threshold is reached, The notification needs to be done, I think if possible, the regulators would prefer that they would be done directly to the data subjects in a way that is clear in plain language, in the language of the data subject, to the extent that you're able to know what that is, communicating the nature of the breach, the contact details of the DPO, or whoever is sort of the point person who can answer any of those questions regarding the breach, and as well as informing the data subjects of the likely consequences and measures that you're going to take to mitigate. So in the event of a large breach, it may be very difficult to reach out to these individuals directly. So an alternative is envisioned where you just provide a public communication that's likely to be seen by, understood by, reach all of the data subjects affected. And if you have questions, you can also confer with the supervisory authority to which you've reported to figure out the best method to communicate that breach to the data subjects.
Although, just as a caveat, there's on the ICO, the initial data breach reporting, they had two ways of doing it. You could report on their portal, or you could call their hotline and talk to a friendly data privacy regulator in the UK, and they could give you advice on things like whether you should notify individuals and how to do it. They are now strongly discouraging anyone from calling the hotline. I think they've been completely overwhelmed in the UK by the number of breaches reported. So these ideas of being consultation and help from the regulators may have sort of met an ugly clash with reality. I just want to talk for a minute about one particular kind of data breaches that we're seeing a lot of and that are particularly challenging under GDPR. Right now, there's sort of an epidemic of these what they call business email takeover, business email compromise, and these are where somebody compromises your mailbox of some of your employees. They're accomplished through phishing. They are epidemic, and they're a hassle, in the U.S. anyway, because if you determine that the whole mailbox has been compromised, if your username and password's compromised, there are sometimes, and you can see what it's limited to what's been accessed, but in many of these instances you can't, and you have to consider the whole mailbox compromised. So in the U.S. you can run a programmatic search terms, and that's, you can search essentially for PII. You can look for driver's licenses and passports and, account information and the stuff that we do in the U.S. If you have a compromised set of inboxes in the EU, particularly if there's somebody like an HR employee, imagine searching for all the terms that constitute sensitive data. So healthcare data, information about sex life or sexual orientation, trade union membership, political views, all of those terms. Imagine anything that would capture anything related to that, including slang terms for sexual orientation in every EU language, as well as the number schemes and names of national ID cards and things like that. It's really, it becomes unmanageable if you try multiple languages of ways of saying, congestive heart failure or diabetes or something that might be healthcare data. It is really, really, really hard and really, really, really expensive so far. Each of these incidents, if you have, if it's a lot of data, ends up being essentially a mini e-discovery matter. So it's driving the cost and the time to investigate these to be significantly, higher and longer than it would have been. So, Betsy, have we scared you yet about having a GDPR data breach?
Yeah, I'm thinking that we just go back to using pens and pencils. I think it's easier. So, the breaches from this end, I guess where we first struggle is making sure that the people in the know what a data breach is, and then making sure that we have it flowing up to the right group, or the right persons in the organization. So, in terms of sort of who oversees data breach concerns or potential data breach concerns, I have a debate going back and forth between, the general counsel's office here where I sit and our chief information officer, because Michael is the one who really understands the nuance of the breach and the IT part of it. And I am the one who pays a little bit more attention to the compliance piece. So, in terms of substance, Michael would be the right one to, as our CIO, to police this. But as he put it, that's like the fox guarding the hen house. And so then you say, well, no, then legal should oversee, sort of oversee any breach concerns. but I'm stealing this from Laura, but it's like the hen guarding the hen house. I don't know if I can spot the fox or not. So right now, the way we do it is it does reside in the general counsel's office, but we've set up a security committee. And so we have a lot of communication and collaboration going on back and forth, and luckily not at this point in a responsive way, but rather in a proactive way. The other piece is that it's the individuals on the ground who really need to identify if there's been a breach that has occurred or a potential breach. And these are people who take a lot of pride in their work, including the security of the system. So, from their perspective, if they have good walls built, and there's a breach attempt, but nothing gets through and nothing gets any bad information, and the system only went down for 20 minutes, then there's no breach, right? And they're not inclined to report it as a breach because, they've done their job and protected the company. That nonetheless, for legal interpretation standpoints, is or may be a breach that needs to be reported. So you have to sort of manage that. What I'm finding is we have to manage it with a lot of communication at two levels, both sort of in the trenches and then at sort of a reporting management level, so that we really have sort of a chain of responsibility and very honestly take any, what I'll call shame away from reporting a breach, because the legal definition of breach is not the same as the legal definition of bad thing happened to my business. So we have to differentiate those two. So I'd say that we are in an evolving, situation right now as we move into this, and as new layers of law get added, that continues to evolve.
That's great. Definitely appreciate those insights. And we'll wrap up here with a little overview of some of the recent GDPR enforcement actions. Got some more details up on the screen, but basically what we're seeing is kind of regulators hitting the low-hanging fruit in most cases. Nothing super out of the ordinary, although we have noticed, as you can see up here as well, the fines do span a pretty big range as well. For instance, Austria just fining 4,800 euros for a company not using its CCTV camera in a compliant manner. So I think we'll continue to see these. One of the interesting insights we had from Helen Dixon, the Irish DPA, who spoke at our offices a couple weeks ago, was she was addressing a question about why we haven't seen more of these enforcement actions when everyone thought the sky would fall on May 25th. What she said in response was that a lot of the regulators are really trying to put together enforcement actions in a slow and methodical way that will stick and not be able to be, readily overturned or challenged by the courts or through the courts by the companies. So sort of an ominous statement that we may see more, but for the moment it's sort of as expected.
Yeah, I think it sounds like the regulators are doing partly what we would expect, which is to make sure that they don't overstep their jurisdiction or, get anything struck down that they do initially. They want to build their credibility, but they also really want this law and the power that it's given them, to be remain in effect and to be upheld. And so I think they're not overreaching right now, but I expect that as they, become more comfortable and as they begin to have more enforcement actions and give more notice to companies as to what kinds of behaviors will be sanctioned, you'll start to see more. But so that concludes our program today. I'm sorry we took the whole time and did not have time for questions yet again. But if you have questions, I remind you, you can submit them in writing and we'll be happy to answer them for you. Thanks for joining us, and we look forward to hopefully having you back next time.